Welcome to the Information Ecology Lecture Series. Our speaker today is our own Arti Rai of Duke Law School, who's speaking on open source biology, the role of law. You should also find or have found copies of our speaker schedule for the course of the semester. Speaking on April 7th, we have Dan Kevels of Yale University, who's talking about patenting life and its parts. And on April 14th, we have Catherine Fisk talking about working knowledge, ownership of workplace knowledge, and the rise of corporate intellectual property. The Information Ecology Lecture Series, which is organized by Jennifer Jenkins, the director of the Center for the Study of Public Domain, and which is funded by the center, allows us to explore a whole series of issues about information, access to information, intellectual property, innovation, and the like. And I'm extremely happy to have Arti Rai talking to us today. Some of you may have seen the very interesting article about her work written in The Economist, which was out by the rapidly disappearing lunches. Or you may have, we also put out copies of her recent article co-written in the Public Library of Science journal Medicine. What Professor Rai and her colleagues have done is to attempt to see if they can apply some of the techniques of open source software, collaborative distributed production, to the extremely pressing and morally pressing case of drug development. And at that, I'm going to leave it and turn it over to Arti. Thank you.
Okay, is this on? Can people hear me?
Yes.
I am very excited to be giving this talk, and I really want to thank Jamie and Jennifer for organizing the series and also obviously doing such a fabulous job of getting the word out to people so that all of you could be here. I'm actually not going to talk in any detail about some of the work that is the subject of the articles that are outside, although I'd be happy to talk about it in the Q&A. What I'm going to talk about is my multi-year empirical project studying open source type projects that others are doing. Scientists, real scientists are doing. All that I have thus far with my co-authors is a proposal that we hope some scientists would be interested in for global health. But what this talk is going to be about and what I've been studying is what might be called open source biology as it currently is already being done. As Jamie has suggested, open source biology is inspired in large part by the open source movement, and many of the scientists involved in these projects do have backgrounds in computer science. However, I put open source in quotes because there are analogies and disanalogies to open source software in the context of open source biology. And by the way, I should note that theory and evidence is a slightly changed the title is slightly changed because I decided, even though I will focus on law, I wanted to bring out some of the evidence that is being gathered as we go through this work. In particular, it has recently been gathered by my fabulous collaborator, Colin Crossman, who has recently joined as the Duke Faculty Fellow at the Center for the Study of the Public Domain. So I think a more precise formulation of the projects that we're studying might be called open and collaborative research. In these sorts of projects, participants work without invoking the usual sorts of exclusionary property rights, whether those be patent rights or equally commonly proprietary rights based on physical ownership of data or tangible physical material. This is different from the way, these sorts of projects are different from the way, as I'll discuss, that biomedical research has historically been done. Even at a time when we didn't, an earlier era, when we didn't officially have proprietary rights, biomedical research was still done very much on a small lab basis. It was very small lab and small firm focused. So the collaborative piece, the piece that is in these projects, is actually entirely new. And not surprisingly, some of the people who also are involved in these projects come from not only from computer science, but also from high energy physics, which is another area where open collaboration has been common in the last century and continues to be in this century. So, in order to give you a sense of what this project takes as its background, I'm going to go through a really quick history, quick and dirty, and needless to say, very simplified history of how biological research has traditionally been done. Of course, it has changed over the years, but nonetheless, there has been a certain continuity as well. So let me give you a quick and dirty history of how biological research has been done. First, so pre-1980, there were few formal rights of exclusion, few formal proprietary rights. Research was typically publicly funded, and in some senses corresponded very well to the vision of science put forward by sociologists of science like Robert Merton, who talked about science as a communal enterprise where there are no official property rights. Everyone contributes to this commons of shared knowledge. So there were some resemblances within molecular biology to the Mertonian vision. On the other hand, there was also quite a bit of secrecy. Merton didn't himself acknowledge any significant role for secrecy in the sciences. And contrary to his vision, there was substantial secrecy in the biological sciences, at least. So this is some really interesting data that has been assembled by Walsh and Hong in a paper they published in Science in 2003, which reanalyzed data collected by a student of Merton's, Warren Hagstrom, data he had collected in 1966. So this is 1966 data, even though it's only been analyzed recently. According to this data, at least, and there are some questions about the precise mechanism by which the analysis was done, but I think overall the analysis is correct. Only 45% of experimental biologists felt comfortable talking with all others, which essentially means people outside their lab. And the number in physics and mathematics was greater, although perhaps not as great as one might have expected, but still greater. So there was a lot of secrecy going on even in the pre-1980 era before formal property rights. Now, many of you probably know about the well-rehearsed history of the move towards exclusionary formal property rights in biology research. The reasons have been somewhat well-rehearsed, and I'll just go through them rather quickly. Molecular biology became commercially appealing for the first time in the mid to late 70s. In 1980, Congress passed a statute called Bayh-Dole, which allowed publicly funded institutions, such as universities, to patent the results of their publicly funded research on the theory that such patenting would help with commercialization because firms would be interested then in seeking exclusive licenses to the patents and developing this inchoate research into commercial products. In 1982, the Court of Appeals for the Federal Circuit was set up, and I think it's not a controversial statement to say that the Court of Appeals for the Federal Circuit has been generous in allowing patents on fairly inchoate basic research. And then finally, in this piece of the, this factor hasn't been discussed as much, but I want to bring it out because it's important for purposes of understanding the rest of the talk. Modularity, I think, also played a role, and you may ask, well, what is modularity? This is a concept of technological design, which essentially means that the innovation task at issue has reached the point where it's sufficiently well understood that it can be subdivided into many different pieces, and each different piece can be done independently, and then the product can be put back together again. But this requires, modularity requires that the innovation task be relatively well understood. So as molecular biology became better understood, it became more modular, and this relates to some extent to some of the reasons why it became more commercially appealing as well, but it's also somewhat distinct. As it became more modular, it became more susceptible to the assignment of property rights, clearly defined property rights, and some economists have argued, including perhaps most prominently Ashish Arora in a book called Markets for Technology, that once technology gets modular, the inevitable result and the desirable result, according to him, is then modular exchange through markets. He contrasts the modular exchange that occurs through markets with the non-modular types of production that take place in the firm. So basically, because molecular biology and its components began to be better understood, property rights could be assigned to the components, and those components could be exchanged in markets. And that's what happened starting in the 1980s. So this is just a graph of university biotechnology patents from 1980 to 2000. I leave to the Q&A exactly how I went about defining biotech patents, but I think the general categorization is more or less apt, and the trend lines are clear. The bottom purple line represents the total number of biotech patents that universities secured, going from about 100 or fewer than 100 in 1980 to approximately 1,200 in 2000. If anything, the percentage went up even more markedly in a completely geometric fashion, going from approximately 2% of the total number of biotech patents in the US to about 11%. So a lot of patenting activity on molecular biology research is the bottom line. Secrecy also went up. This is from a Walsh and Hong paper that it hasn't been published yet, but I received permission to cite it, where they did a survey of secrecy in 1998. And look at the numbers here. 13% of experimental biologists feel comfortable talking outside their lab. So much sharper reduction in the number than in, although there has been a reduction in physics and mathematics as well, a much sharper reduction in experimental biology. We're talking a lot of secrecy here. Other evidence of secrecy, proprietary rights, and the like. 47% of biologists were denied at least one request for data and materials associated with published research. This is according to a survey done by Eric Campbell and published in 2002. In that same survey, Eric Campbell found that a 35% plurality of biologists felt that secretive behavior was increasing. 21% had abandoned promising research as a consequence of being denied data or materials associated with published research, not even unpublished research. And another survey by Blumenthal et al. In 1997 found that 20% of biologists had delayed publication for more than 6 months because of proprietary rights. Now, one question we might ask is this proprietary rights related to scientific competition or money? And the evidence here is not entirely clear. There appears to be some evidence of both. Patents were most influential in the publication delays that were cited by Blumenthal and also by Thursby and Thursby. The reasons for withholding data and materials are less clear. It appears both competition and commercialization play a role, and we can talk in the Q&A about the ways that they could act synergistically with respect to each other to further accelerate proprietary and exclusionary behavior. All right. And then most recently there's been, in response to what is pretty clear evidence, whether motivated by competition or by money, of a lot of exclusionary behavior, there's been a lot of emphasis on access. NIH has put out these guidelines suggesting that biological scientists in particular, because that's who they fund, should try to share research tools freely, particularly if they're unpatented. In 2003, NIH implemented data dissemination guidelines that require all of those applicants who submit grant applications for over $500,000 to have a detailed plan for how they plan to disseminate their data. The National Research Council, a prestigious body of scientists, has published a report on the obligations of publication. You're supposed to disseminate your data once you publish. It may seem somewhat obvious, but it's not been happening. And the NIH has also put on guidelines for the licensing of patented genomic inventions. That's all by way of background. What I'm going to talk about is something that goes beyond access, because all of this emphasis on access still assumes a small lab structure. Each individual lab is doing their own thing. In the ideal world, according to NIH, they would share their stuff more freely, but they'd still basically be doing their own thing in their individual labs. Open source production goes beyond access and is really a new model for biology, because it's not only open in a way that biology may or may not have ever been open before, but also collaborative in a way that biology clearly has never been collaborative in terms of moving beyond the small lab. As I've mentioned, it's been influenced by open source software as computer science has migrated to biology, and there are also, as I've mentioned briefly, some analogies to high energy physics that I'll talk about at the end. The analogy to open source software is perhaps most clear, or at least open source software has been most well studied, and therefore, like all good academics, we go to where the light is. And therefore, I'm spending a lot of time looking at open source software in particular. Ironically, and I don't know how many economists there are in the audience, but I think that the economists have done a particularly good job of studying it. Why? Because they're so shocked that it works at all. And so there have been some really, really great studies by economists that I'll cite. So it has roots in this so-called hacker culture that grew up around federally funded labs and both government and non-government, but both federally funded. In the 60s and 70s, where software was exchanged freely, the introduction of the ARPANET, which was the precursor to the internet, made that exchange even easier. So it has roots in that kind of Mertonian vision, but it goes beyond Merton in having an explicit mechanism or mechanisms for integrating the information. Merton, for better or for worse, never really paid a lot of attention to how all that information that was put into the commons would be integrated in useful ways. And so I think it goes beyond Merton in that very interesting respect. Now open source software has moved well beyond the hacker culture. It's quite heterogeneous and large. 90,000 plus projects are registered at this site called sourceforge.net, which is a repository of open source software projects. And it's moved, as many of you well know, well outside academia. IBM apparently makes a lot of money off of Linux, for example. Some people have estimated as much as $1 billion per year, so it's clearly no longer just a hacker thing. It divides very roughly and schematically into two categories, the so-called copyleft category and non-copyleft. Copyleft software is that software that is available under a license that requires those who receive the software to put into the commons any improvements they make to the software. Again, that's very schematic, very rough, but that's roughly what copyleft software means. It's also sometimes known as GPL software for general public license. Non-copyleft encompasses a lot of different types of licenses, but generally speaking has fewer restrictions on what people can do with improvements and also with respect to mingling the source code of the software with other source code. So as I've mentioned, economists have done a fabulous job of studying open source software because they're so shocked by its existence. And these studies, these empirical studies, suggest roughly two categories of software production. Again, very schematic, very rough. I can go into more detail if people like in the Q&A. One category involves software that is directed primarily to scientific and technical users. Here, the number of contributors is relatively small. They contribute more lines of code, and the code is less likely to be under a strict copyleft license. And so in that sense, it's somewhat Mertonian. Merton never imagined that the stuff that was put into his envisioned commons would be subject to any sort of restrictive license in the form of like the GPL. So it is somewhat Mertonian. It retains that Mertonian flavor, this category of software production. Another category, typically software that is more directly consumer-oriented, tends to have a larger number of contributors, each of whom contribute a smaller amount of code, and the GPL license is much more prominent in that category of software. So why does OS work for software and other information projects? Well, as many people have pointed out, these projects are relatively modular. The information task is well understood. It can be divided up, done independently, and then put back together again. Another economist study, contributors tend to work on particular modules. There's fairly good empirical evidence of that point as well. The contributions are then integrated by the lead developers. The lead developers become lead developers by establishing their particular skill based upon the contributions that they make. And it's very interesting, this Von Krogh study points out that software designers really hate cheap talk. So if you go in onto a particular listserv and just complain about some particular code without contributing the solution, you're dismissed entirely. Whereas the way you get acceptance into the community is by producing a good piece of code, and that's the only way you'll get people to pay any attention to you. Variety of intrinsic and extrinsic motives for contribution, and this is, needless to say, this is what economists have really focused on because they're fascinated by the question of why would people contribute if they didn't make money. The intrinsic motives are sort of the Mertonian motives. People love to do creative things and the like. However, there are a fair number of extrinsic motives as well. Most interesting among the extrinsic motives is that oftentimes the software that's out there doesn't do precisely what you wanted it to do. So you need to make your own improvement to it to get it to do what you need to do, even in your job. A lot of people do this kind of stuff on the job. And once you've made your specific improvement, you don't have a particular problem with making that improvement available to everyone else, because that's not necessarily how your company makes money. It's just what you need for your particular task. Other extrinsic motives that have been hypothesized, less clearly documented, are that somehow achieving reputation in these open source communities can lead to better paying jobs. I don't think that's been as well documented, but there is that hypothesis as well. However, and this is the piece that I think is interesting, modular production of this sort, the economists would say, can also be done through markets. That's precisely how markets operate, through exchanging modular information. It may be that there are higher transaction costs when you exchange information through markets than there would be perhaps in open source, but at least conceivably, markets are pretty good at exchanging modular information. And so the categories of OS research I've been studying, I've tried to divide along these modular and non-modular lines because I think that the interesting economic, legal, organizational questions map nicely onto the modular, non-modular distinction. So most obviously, open source bioinformatics software is a category of open source biomed research, and it is, needless to say, modular. Genomic databases, also as I'll discuss, have become increasingly modular in their production. And then the most interesting category to me is beyond modular information in the wet lab, in the context of so-called systems biology, and how OS production will work in that area and how it does work, I think, is perhaps the most intriguing aspect of this whole area of research. So the Empirical Project has involved semi-structured interviews with scientists who are working on these various projects. One of the reasons that this is an interesting application of the OS model is that most OS research is done in the university, unlike most OS software. And so I also have the pleasure of interviewing technology transfer officers in universities. I put that in quotes. Bioinformatics software, I'll go quickly through this because it has there's some interesting points, but the porting of the OS model is fairly obvious here. There are actually quite a lot of OS bioinformatics software projects. They're used for, or OS is used for the same reasons as used in the world generally, that it promotes information dissemination, reduces duplication according to programmers. Also, interestingly, the scientists can be sure they have access to the code even after they leave the lab. And these are academic labs, for the most part, where if the code isn't OS, the university may not allow them to take the code with them. Licensing. Well, the licenses are less GPL, or fewer GPL licenses than we find in SourceForge as a whole. 47.4%, and this is thanks to Colin's wonderful research in this, of the active projects are GPL versus 72% in SourceForge as a whole. So to some extent, this is consistent with the Lerner and Tirole findings that suggest that scientific and technical projects tend to have a smaller percentage of restrictive licensing arrangements associated with them. Okay, quickly, policies of TTOs. Thus far, there hasn't been a lot of software patenting by most universities. According to one calculation that I've run, this total software patenting by universities has actually dropped from 1% of the total of US software patents to 0.6%. Very fuzzy numbers here, because how you define a software patent is a hugely controversial question. But I think it's fair to say that the real cultural differences, even within technology transfer offices, regarding software versus biology, there are people who focus on biology, TTO officers who focus on biology, and those who focus on software. The software types are quite different, let me tell you, from the biology types. And you might imagine some of the differences in terms of hairstyle, for example. Software, however, one argument you could make is, well, this isn't about cultural differences, it's about money. Software isn't the sort of thing where you can, at least historically hasn't been the sort of thing where you can make a lot of money through software patents. But maybe that's changing, and in the future software patents are going to be more valuable, and we'll see how that goes. It is the case that many universities have thus far exercised a policy or invoked a policy of benign neglect with respect to open source. But they are starting to pay a little more attention to it now. UC, the UC system, which is a huge player in the technology transfer area, is in the midst of formulating a policy. MIT and Stanford report policies in favor of researcher preference. And then there's a division also within the scientific community and the TTO community over whether software should be made open access, i.e. simply free without the source code, versus open source. And we can talk about that, if you like, in the Q&A. So the evaluation of the open source model is not too terribly shocking. The translation of the principles is obvious. The argument would be that OS produces a superior information product. This stands for, with many eyeballs, all bugs are shallow. That's the mantra of the open source movement. There are some incentives issues. Remember that this OS software is produced by academics for the most part. Academics are doing it for the most part not because they're hoping to make consulting revenues off of it, as some OS producers in the for-profit sector do, but because they want to write a piece of code to help them solve a problem. To the extent they can publish the results of that problem, there should be sufficient incentives out there to incentivize scientists to write the code. However, our research is indicating that at least in some established projects, the integration mechanism is considered something of a thankless activity, and therefore, in the larger projects, for example, BioPearl, getting people to do the work on integration as opposed to just writing the piece of code that will help them solve their individual problem is getting harder and harder. Because as you well know, or many of you probably know, the coin of the realm in the biomedical sciences is publication, preferably publication in a journal like Science or Nature or Cell with you as the first author. And if you can't get that out of that can't be the ultimate result of the piece of code you write, then you're going to be less likely to write the piece of code. And then there might be problems with fights over consulting revenues. There have been a few celebrated cases where academics have written OS software, have started consulting businesses based on that OS software, and haven't had to share that consulting revenue with the university at which they're based. Unlike the situation where they'd have to share licensing revenue if the software was patented. So it's obviously a great deal for them not to have to share the consulting revenue, not a great deal for the university or the technology transfer office. So there have been some fights, some celebrated fights over consulting revenues. Genomic databases. As I've mentioned, I think that this area is also becoming increasingly modular with better sequencing machines. The Human Genome Database project paved the way for introducing this modularity, and it also paved the way for the principle of immediate data release. There was some dispute over whether the data would be released under a copyleft type model versus just put in the public domain, and the decision was made simply to put it in the public domain. And then in February 2003, the principles of the Human Genome Project were extended to all large-scale genome sequencing projects. This data is at least to some extent, being improved in a collaborative fashion as well through something called the distributed annotation system, where lots of different people can set up servers and put their particular annotations of the data on that server, and any group that wants to see all those different annotations can then, through the use of the DAS, see those annotations. More recently, the International HapMap project which aims to catalog patterns of genetic variation that are associated with disease, particularly complex diseases, has explicitly adopted, at least until recently, a copyleft model. Basically, it has said that we'll put our genotype data out there, but if you're going to take it, mix it with your own data, and try to get patents on the haplotypes, you can't do that. It recently lifted those restrictions because now it's got enough data out there that people can't really get patents on the haplotypes given what's already out there. But they explicitly decided to adopt this viral/copyleft model because the fear was that, I think the fear was that if people got patents on haplotypes, they could prevent the HapMap researchers from themselves from using those haplotypes in research, because thanks to the Court of Appeals for the Federal Circuit, there is no research exemption for scientists, really, of any sort. So evaluation, well, with the standardized tools, the creation of databases becomes increasingly modular, so the translation of the principles is somewhat clear. Public data avoids transaction cost problems for downstream players. That's the reason why the Genome Project Human Genome Project put its data in the public domain, and why the HapMap project has put its data most recently into the public domain, before that into a commons that was available for anyone who didn't want to who agreed to observe patents. The distributed annotation system might give us the advantage of the with many eyeballs, all bugs are shallow principle, to the extent that everyone, and it's not really clear this is working, but to the extent that it really is the case that lots of people are contributing annotations that are good, it may give us the advantage. Query whether it's actually working or not. Viral licensing of the sort that the HapMap project adopted, I think, could be problematic. And I can talk more about the reasons why. But unlike in software, where patents haven't been shown in any good way or any dispositive way to play any sort of useful role, it's clear that patents, at least as the current system of funding is configured, patents on end product chemicals in the pharmaceutical area play a very important role. And to the extent that viral licensing could in any way touch the end product chemical patent, or perhaps even research slightly upstream from that, it could be problematic. And to the extent that it's being put in to get around the non-existent research exemption, it seems to me that the object of people's attention should be the non-existent research exemption, not this viral licensing. There's an incentives issue with respect to this open source data production, which is that in the biological community, you don't get kudos and publications from just producing data. You get kudos and publications from analysis of the data. So to the extent you put the data out there and somebody else decides they're going to do the first analysis of the data, they're going to get the kudos, not you. So there has been this informal norm in the data community that whoever puts the data out there gets to do the first analysis and thereby gets the kudos. However, there have been at least a couple of people who have pointed me to examples of situations where that norm has been violated, and so one wonders whether the norm will be sustained over time. There was also some technology transfer office resistance to these open source database projects. Basically, NIH in both of these cases mandated that they be open source in the way that we've described, and was able to override the TTOs essentially. Whether what they did was consistent with Bayh-Dole is an open question that we can talk about. Okay, finally, the wet lab, which is the non-modular applications of open source. The example that I've focused on most thus far is something called the Alliance for Cell Signaling. It's one of a group of, it's the recipient of a group of grants that NIH gave a few years ago to try to set up large-scale collaborations on fundamental problems, largely of quote-unquote systems biology, fundamental intractable problems regarding how whole systems, like a whole cell, for example, as opposed to individual genes and proteins within the cell, worked. And no single small lab can handle that large system, these kinds of large systems biology problems. AFCS was the first of these collaborations to be funded, and it's the furthest along, which is why I've been studying it most closely. What it has done, what Al Gilman, who's the leader of this project, has done is glue together, using the terms of the NIH grant, 8 different labs. 7 are wet labs where they actually do laboratory work, and 1 is a bioinformatics lab at UCSD. So what these folks are doing is responding to a problem that is plaguing, at least in part, they're trying to respond to a problem that's plaguing the pharmaceutical industry. As some of you probably know, the pharmaceutical industry has a real innovation drought right now. It puts a lot of drugs into clinical trials, but a lot of them fail either for lack of efficacy or because they produce horrible side effects. And the reason is because people think, oh, you put a drug in there, it'll work only on one pathway and deal with that problematic pathway and cure the disease. But the reality is actually these chemicals / drugs often end up affecting multiple pathways, which is why you get the side effects or the lack of efficacy. So what the AFCS is trying to do is model all the different ways that particular chemicals can affect a cell's signaling pathways. It involves a high throughput analysis of how cells respond to these different drugs / chemicals. The labs use standardized inputs, standardized chemicals, reagents, and the like, but analyze different types of outputs. And the reason that we need an 8-lab model is because there's so many different outputs to be analyzed. The research reports are published on the web after limited peer review. The ultimate goal of all of this is, as I've suggested, to generate a computational model of cell signaling, which presumably would really help us with getting drugs through clinical trials, getting the appropriate drugs to take through clinical trials. So the evaluation. Well, the positives, I think, are that in some ways it's the most interesting application of the open source model. Why do I say that? Well, as I've mentioned, modular innovation of the sort that is being done with software or database production could be done through markets, because at least economists would argue that's precisely the sort of innovation that can be done through markets, because you can get property rights around the modular components and then get those property rights exchanged. Of course, there are transaction cost problems, but let's put those aside for the moment and at least note that modular information can be exchanged through markets. However, it's very hard to do large-scale non-modular innovation of the sort that systems biology represents in markets. And in point of fact, before a lot of technology was modularized, a lot of innovation economists thought it could only be done through a large firm. And the reason is because there are serious problems of incomplete contracting. This is a whole economics literature that I can talk about at greater length, but Oliver Hart has written a lot about this, not in this specific context, but the idea is that before you even know what you're doing in a given area, it's very hard to get people to agree how much of the output they're going to own. You can imagine how difficult that would be. The default rules that are set up for ownership of patents are not very attractive, and we can get into the details of those default rules. In fact, they're terribly unattractive, but it's not entirely clear you could set up good default rules, and I can talk about that as well. And that's, as I've suggested, why large firms were the locus, or people thought they had to be the locus of large-scale non-modular innovation. What happened in the case of AFCS was that the problems of incomplete contracting became so large that Gilman just got fed up with all the bickering and said, you guys, we just all have to disavow any rights. Not easy to do, as I'll discuss in a moment, to get TTOs to disavow rights entirely, but he claims at least he got so fed up with it and the way that it was impeding what he wanted to do that he decided to ask for rights disavowal. So the concerns. Hard to get TTOs to disavow their rights, and Gilman will tell you all sorts of war stories if you get him going on this, particularly about the UC system. And he's willing to be quoted. I guess that's what happens once you get a Nobel Prize. You can irritate anyone you want because you know you're golden. He, like the other lab heads of ASCS, is a senior tenured professor. He happens to have a Nobel as well. What does that mean? Well, it means that he doesn't have to worry that much about whether he's the first author of a paper in Nature or Cell or Science anymore. So he's happy to put all his data out there and not really worry about publication. You know, if we get something published, fine. If not, let's not worry about it. What about the young data generators who are working in his labs? Well, they're often, as matters currently stand, not on the tenure track because they couldn't do stuff that was necessary to get on the tenure track in what they're doing right now. They couldn't get the publications out that they needed to get out. And query whether you want all the young people in your labs to be who are doing this work to be folks who are not on the tenure track, and therefore perhaps arguably folks who are not as creative as those people who would be on the tenure track. AFCS is moving to a more traditional publication model. It's now saying that we will try to, even though we'll put our data up on the web, we'll try to get publications out of it. Whether it'll work or not is a little unclear. They're a little bit worried that there are some journals that might be reluctant to publish articles based on data that's been publicly available for a while. Now, that argument is somewhat in tension with the fact that a lot of, well, for example, the Human Genome Project, a lot of journals were vying for publication of the analyses of that project, but they're still a little bit worried about whether they can really move to a traditional publication model. Okay, what is the long-term prognosis of open source? Well, I think particularly with respect to wet lab open source, the publication/credit model in biology is a real problem. Again, you need publications, you need to be the first author. That's very hard to do, obviously, if you're going to have collaborations and collaborations that put data out there fairly quickly. So is there any possibility of movement to a high-energy physics model? This is what I've been exploring most recently, although I haven't done nearly as much work on this as I'd like to do. There's been some work, some study, mostly by sociologists, of high-energy physics. There's much less emphasis on publication and first authorship in high-energy physics. In fact, there's this phenomenon of what's known as hyper-authorship, where there are 100 authors on a given article, and they're usually listed alphabetically. So you might ask, well, how do you determine who's any good, who's doing the real work? And it seems to be the case that people know because they know the community. They know who's good based upon just knowing who's in the community. So it's based upon a contribution. People know who's made the contributions to particular projects. And if you think about it, that is not that dissimilar from open source software. Open source software has a list of contributors, and usually, or oftentimes, that's alphabetical as well. But if you talk to anyone who's in the project, they'll tell you, well, this guy, it's not often, unfortunately, a guy, this guy and this gal and this guy are the ones who really did work, and the rest, you know, they're just listed. So it does seem to require a relatively small community that trusts each other not to claim credit where credit is not due. And I'm not sure whether we could get that going in systems biology, but it's certainly something that might be worth exploring if we think, and as I do, that systems biology is going to be very difficult to do through a small lab-based model, that we'll need these large-scale collaborations, and that we probably don't want it being done in large firms, and they probably won't do it to the extent we want done anyway. So thank you. I welcome your questions. As I mentioned, this is a 5-year empirical project, so as you might imagine, I'll be very eager to hear your thoughts and comments. David, I get to call my own questions because Jamie has done.
Fly up the wall.
We have about 15 minutes.
Oh, okay.
No, I'm just saying for questions.
I thought that was magnificent. I don't know whether you can hear me. Are you able to hear me?
Yes, I'm able to hear you.
I'm surprised at how interesting I think this is.
It's about patents, after all.
But you know, that's exactly it. But I'm actually fascinated by what you've had to say, and by the promise it seems to show. But I want to ask you, if you can, to zero in, unless this embarrasses you or us in some way, on Duke and how it responds to the ideas that you're entertaining.
Who's here? Is there anyone representing the administration?
I was here, of course, when Bayh-Dole was brought into force, and remember the travail that accompanied our conversion to that system, because until then, there was no patent policy, and researchers felt free to publish whatever they were working on when and as it came to fruition. And then all of a sudden, the patent policy was put in effect, and in effect, as they saw it, the people in that community began to see their work and something that they had had a long-standing investment in suddenly wrested away from them in exchange for just some royalties that rode on the agreement. And I think I went on to that patent committee about that time, and I was on it, either on it as a member or as chair, until 1994. And in that period, about which I know something, it would, it seems to me, have been extremely hard for you to envision the kind of work, this kind of open source collaboration that you proposed, because it's really pre-Bayh-Dole in a sense, or maybe it's post-Bayh-Dole, but it's not the way the university, I think, would have thought of things in that time. You referred to the problem as the TTO problem, but it wasn't just in the tech transfer office. It often went really to the most senior officials at the university, and in our own time, the last president before the one we now have was at one time a very, very strong proponent of the most vigorous appropriation of individual rights from faculty members across the whole university. I mean, when the intellectual property policy, which is different from the patent policy, was being negotiated, there was a movement for a while to make everything that we wrote not for invention, but for copyright, the property of the university. Now, all of this is by way of just a kind of quick background. I suppose that at Duke, something must have changed if this is feasible here. And my question to you is...
Well, Duke isn't part of AFCS, just to let you know.
Is it going to change? Is it in the process of changing? Are we a holdout? Where do we stand on that?
No, I think Duke is perfectly representative in not, I mean, if I didn't make it sufficiently clear in the talk, I should make it clear that in addition to the publication/credit issues in biology being an obstacle, universities are also an obstacle. I guess I should make that clear. And I thought I'd made it clear, and Duke, I think, Duke is actually slightly involved with AFCS because there is, but not in terms of the laboratory work that would yield any intellectual property rights.
I thought you were completely clear about that. What I'm really asking is whether there is any enthusiasm at the top as well as from other levels.
There's a lot of enthusiasm at NIH. In fact, this is what they're really enthused about. One of the reasons I suspect I've gotten some money to do this is because they're very excited about this. They really think that these large-scale collaborations are the way to go in order to achieve any progress, because I think a lot of people are thinking that this pharmaceutical drought is not just a statistical blip, that it really indicates something. So from the funders, there's a lot of enthusiasm. That's where the leverage would presumably come if leverage had to be applied, which I think it will have to be applied. And I think, if there's a message in my talk, it's that, and it will be the message to the funders, that you guys really have to push this, otherwise it's not going to happen. For multiple reasons, both the publication credit model and the universities. Yeah.
Well, terrific work. Keep expanding the frontiers of this investigation. I guess the question I have in my mind, and I don't know whether you're even close to seeing the problem emerge or not, I guess I'd phrase it this way. What happens when the successful large-scale collaboration turns up a system that has enormous commercial application?
Right, good. Yeah, well, thus far, the large-scale collaborations that have been funded are unlikely to lead to drugs per se. They're going to be slightly more upstream of drugs. But you're absolutely right that the difference between high-energy physics and biology is that high-energy physics, for the most part, it's not like the Fermi Lab is going to produce something that's going to be $1 billion blockbuster. So this is good. And I think that's, I think that's why viral licensing is quite problematic because it makes it even more difficult to attach proprietary rights further downstream, unless it's done in a very careful manner, and I don't think thus far it's been done that carefully by NIH, among others. Yeah, and I think that this is, thus far, so long as we fund the large-scale collaborations on fundamental non-modular problems, I don't think we'll get too far into obliterating patents on drugs, but that could be a problem with certain projects.
Obviously, that's an interesting question. That's where I would see where we could get somewhere with the liability rules. And I had the satisfaction of being on a panel with you know, the nutty founder of Copyleft.
Stallman?
Yeah, and he was going to give a comment after I gave the general theory with regard to application of traditional knowledge, and he had to run off for a plane, and he had been criticizing everything and everybody. He had been a real pest. This was at the Future of WIPO conference. And then he got suddenly very red in the face. He said, well, I have to go, but what I want to say is I think this is terrific. I think this solves all the problems. This was with regard to traditional knowledge, and it should be more widely known, and then off he went. So all I'm suggesting is that this intuition that we might oil the friction, reduce the friction with the commercial markets through liability rules might have some traction, and this is where I would see it coming in, actually. And then over the margin a little bit.
So, so in certain projects, perhaps you wouldn't have information necessarily being placed in the public domain. You would have it being placed in some sort of repository that was subject to liability rules. Is that what you're? Yes.
It would still remain
within
the commons there. And then the next interesting question would be, what if, you know, this tension that we're all dealing with, if the commercial applications turn out to be universities is the only market for the commercial application, we go around in circles, right? We want it to be free so universities can do it, and then the universities insist we spend a lot of money on this. How are we going to recuperate it if other universities don't contribute to it, right? And there again, you might solve it through a liability rule that would avoid some of the free rider problems that might attach to it.
Yeah, that's conceivable as well. Actually, I was going back to your first thought about liability rules being attached to the information that was put into this repository for commercial purposes. Do you think that that would give, I mean, the reason patents and exclusive licenses work is that, at least for drugs, the theory goes, is because it gives the exclusivity you need. Would a liability rule sufficiently give you that exclusivity?
$64 million question, but everywhere that they're used, they've worked. The problem is again, a tail chasing the monkey around the flagpole. If everybody is used to an exclusive property right, that usually gives them a lot more than they need. Then they say, we need this. And the question is, if it turns out that competition supplies half or three-quarters of what you really need, if you have the liability protection, then you have different expectations for your investment calculus. But there is certainly a period of breaking in and getting used to the things you can't do. Nevertheless, there are an amazing amount of these rules. Unfortunately, we don't have the money. We didn't foresee the empirical thing, so we can't demonstrate it as well as you can. There are an amazing amount of these that are actually working and frictionlessly.
Bob?
They wanted to ask you a question about, I think a lot of your policy options are going to loop back to organizational behavior.
Yeah.
Right? And you've staked out the position that NIH actually wants this stuff to be out there because its mission is to promote the science. And they're in a very unusual situation that their appropriation doesn't really, they've got a very, very tiny stream of funding coming from their patented inventions.
Yeah.
And one of the reasons that the universities care about securing rights is because of the Axel patent, Roland Boyer patent, Strider patent, things that generate income for them. You could solve that through a liability rule, but that's not what we've got. So I'm wondering.
Although that was essentially a liability rule.
It was.
That's kind of how it worked out.
Yeah.
That is kind of how it worked out.
Yeah.
But the the thing they're trying to do is secure a stream of funding, and for a Stanford UC or a Columbia, that's actually a big deal, and that's what the other universities want to be. They don't want to screw up the research process. They want to get the stream of funding and get their fair share of the ultimate innovation.
Right, right.
How are you thinking that, aside from the two options you've got on the table, patenting and some liability rule that we haven't yet constructed,
Mm-hmm. How are they going
how do
to?
you get there, and how are you thinking about that as you're interviewing your tech licensing offices?
Yeah. So one strategy, which is perhaps has the virtue of truth as well, is that by definition, if this is a large-scale collaborative project, or not by definition, but presumably if this is a non-modular large-scale collaborative project, there are not going to be good property rights to attach to it for the most part. I mean, we might be lucky and maybe get something good, a carefully delineated tool, for example, to which property rights could be attached. But for the most part, we're talking almost by definition, since it's non-modular, of stuff to which property rights may attach at the very back end, but for a long time, you're not going to get any money. So if we're hoping that these TTOs are discounting the future fairly acutely, so at most they maybe get money 20 years down the line or 15 years down the line, they won't be so worried. And that's, I take it, in part what Al Gilman was also able to convince these folks of, that yeah, it may be that 15 years down the line, something interesting that could have property rights attached to it will come out, but we assume you discount the future well, and 15 years from now, revenue stream is not a particularly good present value. That worked there, although it's hard to figure out how much of it was, just his being who he is and browbeating people, versus how much they really thought there wasn't money to be made until the distant future. Jonathan?
I want to go back to the distinction between the firm and the market.
Yeah, good.
At the beginning. If the kind of research that's really valuable here is this large, non-modular, collaborative work in a community that shares a lot, then that might be better handled in a hierarchical organization rather than through exchange of modular components in arm's length market transactions. So
Right.
that was really Coase's key point in 1937.
Yeah.
The firm versus the market per se. It was hierarchy versus
Okay.
contracting. Or
Fair. That's fair.
right.
That's fair.
So,
Okay.
So why not do this? Why not avoid some of these the barriers erected by intellectual property rights in private firms and even in universities, which are nonprofits, quasi-public, by having this all done in public agencies. And I guess maybe the Human Genome Project is an example of that. I don't know.
It was getting there.
It's successful.
Yeah, there's a project that's a more immediate example of it. I think it's called the Chemical Genomics Project. Have you heard of this, Bob? It's being done intramurally at NIH, where they're essentially just throwing chemicals at targets and seeing what comes out. I think that's a fair way of putting it. Yeah.
Other big science projects in the past, whether
Yeah.
it's NASA or Manhattan Project
Right.
or other Human Genome Project or others, if what you need is lots of collaboration and sharing instead of lots of competition and barriers, then why not do some of this stuff in public agencies?
Yeah, so that's another option, sort of a Manhattan Project for drugs, in certain areas at least, where drugs seem to be hard to, where there aren't low-hanging fruit, drugs seem to be hard to find. And I've been thinking about that as well, because that's clearly the reason that the norms of high-energy physics evolved as they did, is because there were certain large facilities to which all the scientists had to go and exchange information with each other, and therefore the small lab, I think that the small labs created the opposite sort of behavior, created that hoarding kind of behavior, whereas these large facilities where you had to go and exchange ideas with lots of other people and so forth created the kind of community that we see in high energy physics. So that may be the perfect way to do it if we could, if that would be politically feasible.
Could I ask you a follow-up just on where we were? What I've got, I'm sorry, but we may not touch exactly this point again for a long time. Your point about what about the fact that they wouldn't have the exclusive property right to lean on if we get the commercial application? Well, one answer that Tracy and I have come up with that has, we think, a lot of empirical weight to it is that as a compensation for that, you get a claim to all the unpredictable and unspecified uses, which are likely to be very large with regard to these projects. And you avoid the risk of impeding them by your refusals to deal. And in the long run, this might encourage much greater use of this mechanism. Does that make any sense to you?
I think I'll have to understand it a little bit better, but I also think people unfortunately have to leave. So, nobody should be held hostage to my lack of understanding. So if you want to leave, please feel free. And then Jerry, you and I can take this offline. Thanks.